So I'll continue to take a look at this patent case between HYLN and Range Energy. And HYLN did respond to it, and they requested a motion to dismiss 12 counts of Range Energy's complaints. And the judge granted that motion to dismiss 12 of those counts. And originally, Range Energy filed the case in federal court, and then that got transferred to a district court in California. And it says the allegations in the complaint fail to create a substantial controversy of sufficient immediacy and reality required by Article 3 and the Declaratory Judgment Act to support subject matter jurisdiction in this court over the claims for infringement and invalidity of 6 patents. And in Range Energy's original complaint, there's 16 different counts. And subject matter jurisdiction has to deal with the court's ability to be able to handle the case. And it keeps referencing all the time that Range Energy, it's their complaint's based on a single bare equivocal statement in a single letter that Range Energy is or may be infringing several additional patents in HYLN's patent portfolio, which were not accompanied by claim charts, infringement analysis, or any revised licensing demand tied to those patents. Here, the first commercial deliveries of Range Energy's e-trailer product are not expected until late 2026, with this expected commercialization date having been repeatedly pushed back. Range Energy itself has asserted in its February 13th, 2026 letter that it has yet to generate any revenue from its e-trailer product, such there would be no damages for any infringement, and on that basis, any infringement lawsuit filed by HYLN or any of its patents would be frivolous, contentions HYLN disputes as a matter of law. So apparently, they were disputing Range Energy's these some of the patents that they filed in. There was an issue with one of the inventors he didn't certify it, and then apparently HYLN had to go and then quickly fix that issue with the U.S. Patent and Trade Office. And he said, this is HYLN's response: Range Energy filed this declaratory judgment action, that's with the court, on March 17th, 2026, which was just 4 days after the last communication between the parties. The complaint asserts claims for non-infringement and invalidity as to all 8 patents in the portfolio, including the 6 additional patents that were the subject only of that single equivocal sentence. Meanwhile, during that same period, HYLN filed requests for certificates of correction to 2 of the patents on March 12th, 2026, just days before Range Energy commenced this action. So HYLN goes to fix this technical issue with 2 of the patents, and then immediately after that, Range Energy files a complaint with the court telling HYLN to go away. The certificates of correction were not subsequently issued until April 14th and April 7th, 2026, respectively, weeks after the complaint was filed. So the court's response to this, and this was made by the Honorable Yvonne Gonzalez Rogers, it is hereby ordered that counts 1 through 5, 7, 9 through 13, and 15 of the complaint asserting claims for declaratory judgment of non-infringement and invalidity as to U.S. patent numbers, and it lists 6 of them, are dismissed without prejudice for lack of subject matter jurisdiction pursuant to Article 3 of the United States Constitution and the Declaratory Judgment Act 28, USC Section 2201. And of course, they like to generate lots of paperwork here. Let's go to the next document. HYLN admits that following the strategic shift towards power generation solutions and linear generators in November 2023, HYLN announced to its investors it would maintain its hybrid electronic powertrain patent portfolio for future use or sale. And I do recall hearing that. HYLN further states it invested approximately $400 million in its hybrid electric powertrain technology, building over 50 units, deploying the units in internal test, and selling the units to customers. Now, I don't know about you, but I don't really remember HYLN selling trucks to customers. I know that they were going to do it, and then they did that pivot or strategic shift towards the Carnot generation. But I don't remember it selling units, which I assume that the units are trucks to customers. So I'm a little confused. HYLN's hybrid electric powertrain patent portfolio embodies pioneering innovations in electric vehicle and trailer technology and represent protectable rights that HYLN actively enforces. It would make sense to me for them to actively enforce it if they did stuff with trucks, but they don't do anything with trucks. It's like if they're doing stuff with generators, which they do now, and if they had some other 3D printing company that produced generators like HYLN's, then yeah, go after them. But here, I don't see where trucks or anything haven't done with trucks. Background facts. And HYLN has to respond to every single paragraph in Range Energy's complaint. That's a lot of paperwork, but we can get some more information out of their response, and this is HYLN's response. And they can either admit to certain paragraphs, deny the paragraphs, or admit to it, but this A, B, and C, or deny but A, B, and C. HYLN denies the characterization of the letter as a demand, but rather that the letter reflected a good faith effort by HYLN to resolve its valid infringement claims without litigation. HYLN states that Range Energy's CTO and founder, Ali, emailed HYLN CEO Thomas Healy. So Thomas Healy was involved in the beginning to connect on the proposed license on September 3rd, 2025. And the founder of Range Energy and Healy then had a telephone call on September 18th, 2025, during which Ali proposed that HYLN work with Range to find a way around infringement. A video conference between the parties was finally scheduled for October 24th, 2025, during which Range Energy expressed that they did not want to discuss the infringement issue, but rather wanted to focus on the purchase of the patent portfolio, and that HYLN would get back to Range Energy on a proposed acquisition price for the portfolio. So at some point, Range Energy wanted to buy the patent portfolio. But keep in mind that Range Energy is a startup and they don't have a whole lot of cash on hand. HYLN admits that Range Energy's outside counsel sent a response letter to Pincus. That was the original lawyer involved. HYLN has multiple lawyers working on this. They have Brent Pincus, that was the original one, and then they have two additional lawyers that are licensed to practice law in California, and one of them is crafting all these letters to the courts. So Brent, I think that was his name, Brent Pincus. Pincus had changed firms to Spencer Fane, and the letter was only later received when it was re-forwarded by Range Energy to HYLN on October 20th, 2025. So Pincus left on August 20th, 2025, and HYLN sent a response to Pincus, but Pincus didn't work at he didn't work at his old employer. He moved, but it took 2 months to re-forward the Range Energy response to HYLN on October 20th, 2025. So there was 2 months of just downtime. HYLN denies the characterization on the November 14th letter as a demanding call between the parties, as there was uncertainty around the date for the next conversation between the parties when the next conversation between the parties was going to take place. HYLN denies the characterization that Govey's emails to Harris demanded a meeting with Range Energy. HYLN admits that on December 10th, 2025, Govey of HYLN sent a letter to Range Energy that included a licensing proposal and an alternative proposal to sell the patent portfolio. So there is another attempt to sell all of this powertrain technology that HYLN no longer uses, as well as a licensing proposal. HYLN admits that a video conference call between the parties occurred on March 13th, 2026, and that Range Energy's Harris made a new unreasonably low offer to license HYLN's hybrid technology. So they lowballed him, and HYLN didn't like that. HYLN denies that Govey stated that HYLN would not respond to Range Energy's officer, but rather that he expressed HYLN's disappointment with Range Energy's offer and stated that HYLN would discuss Range Energy's offer internally and decide to do what is best to protect its patent rights. And look at it. There's just all these like deny allegations in paragraphs. Thomas Healy. The patents in suit represent the culmination of Healy's and his team's years of pioneering work developing hybrid electronic powertrain technology for commercial trailers. HYLN's invested substantial resources in developing, patenting, and commercializing this technology. Now, I don't know about you, but did HYLN commercialize the trucks? I don't recall that happening. Did HYLN commercialize the Carnot generators? That is yet to be seen. HYLN first identified Range Energy as a potential infringer of HYLN's hybrid trailer technology patents as early as December of 2022, based on Range Energy's own public statements and conduct. At the April 24th ACT Expo in California on or around May 20th through the 23rd of 2024, Range Energy employees approached HYLN's booth and spoke with HYLN's CTO Josh Mook, describing Range Energy's e-trailer product as picking up where HYLN left off in hybrid trailer technology, reinforcing HYLN's belief that Range Energy was infringing. They're just rubbing salt into the wound. Additionally, at the same ACT Expo, Range Energy's Adam Smith, and Adam Smith is kind of like the equivalent of Govee. Adam Smith made similar representations to HYLN's chief commercial officer, Govee Ramasamy. These representations reinforce HYLN's well-founded belief that Range Energy's e-trailer system infringes the patents in suit and is doing so without a license from HYLN. Now, HYLN is countersuing Range Energy. Range Energy, actually, they demanded a jury trial, and 12 of the 16 counts are dismissed. So there's four counts remaining from Range Energy suing HYLN. And now HYLN is suing Range Energy, and they also demand a jury trial. I mean, this is where part of your investment dollars are going towards this lawsuit between these two companies. Counterclaim 1, and this is they're going after two patents in particular. Range Energy has infringed and continues to infringe one or more claims on the 853 patent, including at least claim 16 directly or indirectly, literally and or under the doctrine of equivalence, making, using, selling, offering for sale, and or importing the Range Energy e-trailer system in the United States without authorization from HYLN. HYLN has suffered and continues to suffer damages as a result of Range Energy's infringement. What damages are they suffering from? HYLN does not sell trucks. They discontinued it due to a weak freight market. And then there's a counterclaim count 2 on a different patent. This is a patent ending in 029. And it's the same legalese that they are using this without authorization from HYLN. And again, they state that HYLN has suffered and continues to suffer damages as a result of Range Energy's infringement. HYLN does not sell trucks. Show me where HYLN sells trucks. Show me where HYLN commercialized trucks. I don't recall those things happening. Maybe I have like long-term, short-term memory loss or something, and I just don't remember. HYLN has 3 different lawyers working on this. Range Energy has 2 lawyers working on it. Oh gosh. That this court award HYLN damages adequate to compensate it for Range Energy's infringement of patents in suit in the amount to be proven at trial, but in no event less than a reasonable royalty as provided by 35 U.S.C. Section 284. Demand for jury trial. Pursuant to Federal Rule of Civil Procedure 38B, HYLN Inc. hereby demands a trial by jury on all issues trialable by jury, including all issues raised by HYLN's counterclaims. So that's it for this wonderful video. We'll see if what HYLN does for this upcoming Q1 2026 earnings, and he probably won't bring this up at all because it doesn't make HYLN look good. He needs to hype it up in other ways.